welcome you to the Mercy and Justice Conversation Series we're having this year in honor of our Holy Father's extraordinary Jubilee year, soon to conclude at the end of November. And this colloquium has been going on back and forth between law and theology and philosophy.
I hate that.
So
I hate that.
if we could begin now with a prayer. Professor Molly Murphy will lead us in an opening prayer.
In the name of the Father, and the Son, and the Holy Spirit, amen. Let's say a prayer that, for our patroness, Our Lady. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen.
Our guest presenter today is Richard Stitt, from Professor Emeritus from Valparaiso School of Law. He took his bachelor's degree as AD from Harvard, his MA from the University of California at Berkeley, a Master of Philosophy degree at Yale, his JD from Yale, and his PhD from Yale University. At Valparaiso, Professor Stitt has taught criminal law, comparative law, European federalism, legal philosophy, and American legal history. His articles are too numerous to refer to. He has just returned from a tour of Paraguay and Chile and has presented expert testimony at various venues in those countries. Our first respondent will be Professor Robert Vestighi, Professor of Systematic Theology at Sacred Heart Major Seminary. Professor Vestighi has many accomplishments, but I would just like to emphasize his serving as the executive editor of the Catholic Encyclopedia and the Denzinger Compendium on Systematic Theology and Dogma. Both of those publications require his expert handling. Our second respondent is our own Professor Richard Myers from Ave Maria School of Law, with his undergraduate degree from Kenyon College, graduating summa cum laude, his JD from Notre Dame School of Law, summa cum laude. His area of expertise is appellate litigation, constitutional law. He's served as the president of University Faculty for Life, and before joining us, Professor Myers served time with Jones Day, the largest law firm on the East Coast. It's an honor to have these distinguished panelists here with us today. And without further ado, Professor Richard Stitt.
Thank you very much for having me here today. You know, it is always a tremendous pleasure for me to return to Ave Maria. One of the greatest joys of my law school career was reading that Ave Maria had been founded. You know, it was just a tremendous light, like the Magi seeing the star of the east. You know, holy cow, that's what this, I thought, this is it. And you know, if I had been just out of law school at that point, I wouldn't have applied. It would have been my first choice to come here to teach, no doubt about it. I already had faculty at 79, and it was too late to make a big move. But you know, I just admire you guys so much. The commitment and the quality that you guys show is just a tremendous asset for our nation and for the law. I did want to make one correction though. I'm not emeritus. Emeritus always sounds like some crunchy old guy. I have a different title. I'm a research professor. Now, there really isn't much difference. I don't get paid either way. But it makes it sound like I'm still thinking. So, anyway, and the paper here that I'm going to be translating as I go along was originally written in Spanish for the Paraguayan Supreme Court. Now, there's a country, I tell you, I don't think you guys drop out of law school right away and move to Paraguay, but I mean, Paraguay has a solidly pro-life Supreme Court, a solidly pro-life executive branch, and a solidly pro-life legislature. And they invited me to speak, the Supreme Court invited me to speak to to the lower court judges, in particular the family and juvenile court judges, on pro-life, because those are the people who see where the rubber hits the road and who really need to understand we have doctors speaking about biology, and I was speaking about, I gave a couple of talks, one of which was this one, about Roe v. Wade. Why was that important for Paraguay? It was important for Paraguay because we have our judicial decisions, just like everything that's American in the world, has a tremendous impact throughout the rest of the world. People assume if something is American, it must be good, whether it's music or basketball or anything. If we have it, they must need it. So anyway, Roe v. Wade is always in danger of having an influence in other countries, so I wanted to sort of inoculate Paraguay against such an influence. But when I heard about your wonderful series on mercy and justice, I thought really this talk could be adapted very, very clearly to the theme of mercy and justice. Because in a sense, what Roe versus Wade was doing was being merciful. If we read from Roe versus Wade, Justice Blackmun in that decision wrote, you can see this compassion for the woman caught in an undesired pregnancy. He says, maternity may force upon a woman a distressful life and future. Psychological harm may be imminent. Mental and physical health may be taxed by childcare. So it seems a very sensitive appraisal of a pregnant woman. I frankly never realized how difficult the situation they were in. Myself, I mean, it's pretty. His heart is going out to pregnant women, and the remedy that he supplied is abortion on demand. But there's another aspect of mercy that I think is significant here. Mercy in the sense of the mercy of God especially, but even human mercy, is something that is gratuitous. It's something that is not tied to logic or to reason. It's not a syllogistic conclusion. We must let this guy off because, no, then that would be justice. If it were an issue of justice speaks in terms of must and of logical syllogism. Mercy is gratuitous. Okay, he doesn't deserve this, but we're going to give it to him anyway. So that's mercy. Well, that's the language of Roe versus Wade. It's not found in the Constitution. It doesn't follow logically. They just did it. They, as a kind of act of mercy, in their opinion, they thought it was an act of mercy, to pregnant women, to give them this option of abortion. So it really does kind of exhibit this, the compassion side of mercy and the gratuitous side, the non-logical side of mercy. But at the same time, it completely lacks any sense of justice toward the unborn child, or the father, or as we'll see in a moment, even the mother herself. But it doesn't talk in terms of requirements of justice. And our President Obama has said many times, and I think in many ways, President Obama, was not a bad president. It has not been a bad president, certainly better than the alternative that we just avoided. So, and one of the wonderful things that he said, of many wonderful things, is the arc of the moral universe is long, but it bends toward justice. So the theme of this lecture today, for this context, is that Roe v. Wade attempted to ignore justice, to concentrate only on mercy, but for that reason it has been rejected again and again in the name of justice. The first rejection of Roe v. Wade, about which I'm going to speak, is the rejection by the German Constitutional Court. That's a very important point. We'll come back to all these. It was also been rejected by academics and feminists who are personally in favor of abortion. They still rejected Roe versus Wade. It's been rejected by state and federal legislation that has actually found a way to protect the unborn child despite Roe versus Wade. And it has really been rejected by the Supreme Court itself, in that the Supreme Court has never reaffirmed its reasoning and has followed its conclusion the right to abortion on demand throughout pregnancy simply because of the doctrine of finding precedent of stare decisis. But most surprising of all, what I think of as the key doctrine of Roe versus Wade, two parts of it: the depersonalization of the unborn child, saying the child is not an actual human being, but just a potential human being. And on the other side, the right to abortion on demand throughout pregnancy. That key doctrine especially the second hand, was rejected by the authors of Roe versus Wade itself. Justice Blackmun and the majority of that court did not want abortion on demand. They rejected it. Their decree mandated abortion on demand, but they thought that's not what it did, and that's not what they wanted. So they actually rejected their own decision, or the meaning of their own decision. Now let's look a little more in detail at Roe versus Wade so we know where we're starting from. You guys know all this already. I had to spend more time on it down in Paraguay, but just very quickly, the Roe versus Wade grants zero constitutional rights to the unborn child prior to birth. Hillary Clinton had it exactly right in the campaign when she said, the unborn person has no constitutional right to life. That's what the court said. But the court went beyond just that. It said not only does the unborn child have no constitutional right to life, but the unborn child cannot be given a statutory right to life. Now, I mean, animals can be given a statutory right to life. The state can protect bald eagles, pointed darting in the hot litter to protect the eagles. So, I mean, but, no, not for unborn babies, though. There can be no statutory right to life at any time prior to the point at which the child is able to live independently outside its mother, which at the time of Roe versus Wade was about 28 weeks. The Supreme Court called that viability, but it's not. The old use of the word viability, a viable pregnancy was one at any stage, which didn't have some internal sickness that was going to destroy the child. A viable embryo can survive. So you need a viability, you have to live independently. And they invented that and put it in 28 weeks. But even worse than that, even in the last 12 weeks after viability, the Supreme Court in Roe v. Wade said there could be no protection for the child in the case where the mother could allege any sort of health reason, any sort of, and the health reasons included emotional, psychological, and familial health. So that's why people on both sides of the fence, on both sides of the argument for and against abortion, frequently summarize Roe versus Wade as mandating abortion on demand virtually throughout pregnancy. Well, no, better to put it, abortion throughout pregnancy virtually on demand. I mean, as long as the woman can find somebody who will say, some doctor will say her emotional health will be better off if she has the abortion, then she has a right to abortion right after birth. If she's very unhappy about the pregnancy because her emotional health is going to be better if she can convince some doctor to do that. Our situation of abortion virtually on demand throughout pregnancy is shared by only 3 other countries in the world: Communist China, North Korea, and Canada. But even that summary is a little bit too generous to Roe versus Wade, because Canada, the reason why Canada permits abortion on demand throughout pregnancy is because of the political impasse. The Supreme Court many years ago, many decades ago, struck down their abortion law for rather technical reasons, and they were then given, but you guys can go reenact it as long as you overcome these technical problems and so on. But the conservative, the pro-life groups in Canada don't want a law, don't want to sign on to a law unless it's pretty restrictive. And the pro-abortion groups don't want to sign on to a law unless it's pretty wide open. So the result is they haven't been able to pass any kind of law. And it's more extreme than even the pro-abortion groups would have wanted on demand throughout pregnancy. But it's because of this political impasse. There's no institution, neither the court nor the legislature nor any other executive branch in Canada that has fought through and mandated abortion on demand throughout pregnancy. By contrast, in the U.S., along with Communist China and North Korea, there has been an institutional decision to mandate abortion virtually on demand throughout pregnancy. We are not in good company. By contrast, just 2 years after Roe versus Wade, the German Constitutional Court explicitly rejected Roe's doctrine and said the doctrine that the fetus is only a potential for human life, and said, on the contrary, that the unborn child is constitutionally protected throughout pregnancy. These are the words of the German Constitutional Court. The process of development is a continuing process that exhibits no sharp demarcation and does not allow a precise division of various steps of development. The process does not end even with birth. The phenomena of consciousness that are specific to the human personality, for example, appear for the first time rather long after birth. Therefore, the protection of the Constitution cannot be limited either to the allegedly completed human being at birth, nor to the child about to be born that is capable of living independently. Nor may any distinction be made among the other diverse stages of life before birth. The court referred to no religious belief as a foundation of this decision, but it does say that their experience with Nazism requires them to avoid any step along the path that would lead to rejecting the inviolability of individual human life. So they rejected their Nazi experience, led them to this insight. Later on in 1993, the court put their reasoning even more beautifully. I'm paraphrasing here, but it's just as clear and beautiful in German. Wherever human life exists, there is always human dignity. And wherever human dignity exists, there is always a constitutional right to life. And the German court furthermore emphasized, and the legal experts in this group will appreciate this, that the unborn child was not just declared to be a parental interest or a state entity. The German word is Rechtsgut, or Spanish, bien legal, but rather to have its own right to life. Sein eigenes Recht. Its own right to life. Person, legal person, possessing its own right. So we see that in Germany, the court did not forget justice for the unborn child. Didn't forget mercy to the mother. No, I can't go through this decision now, but there's a lot of it talks about the duty of the state to protect the child by strengthening and empowering the mother in a difficult situation. If she's going to lose her job, if she's going to not have be slowed down in her studies, if she can't find an apartment large enough for her and the child to live in, if she has trouble recovering paternity money from the father, in all those situations there is a constitutional duty to rescue her, to come in and help her. So the Supreme Court, the Constitutional Court in Germany, held on both to justice for the unborn child and very strongly to mercy for the mother in distress. So that's the first major rejection, the German Constitutional Court's rejection of Roe versus Wade. Another rejection has been at the popular level in the United States. You know, the recent surveys show that only the one that Clark Forsyth, I'm going to mention, by the way, there's a book that a friend of this law school, a friend of mine, great lawyer for Americans United for Life, Clark Forsyth, published in 2013 called Use of Discretion, where he went through the whole process of Roe versus Wade. We're going to come back to that later. But one of the things he emphasized there is that he cites surveys which show that only 7% of the American people support abortion for any reason throughout pregnancy. Now, I've seen other surveys that showed 9% or up to 13%. But even if it's 13%, it's a tiny minority that is in agreement with Roe versus Wade. Now, you might say, well, but if you go out and have a survey and say, do you approve of Roe versus Wade, or do you want to overturn Roe versus Wade? It's true, a bare majority, like 51, 52%, says yes, we want to keep Roe versus Wade. But why do they do that? Because the media have never revealed, for 40 years, 40 odd years, they have never revealed how extreme Roe versus Wade is. In the same surveys, people who call themselves pro-choice, a majority of people who call themselves, they self-define as pro-choice, do not want any abortion after the first trimester. Now, that's just 52%, but anyway, it's a majority after the first 3 months. And by the third trimester, where Roe v. Wade permits abortion for any emotional reason, I can't remember, 72 or 79% of people who call themselves pro-choice reject abortion during that third trimester. So, I mean, Roe v. Wade is out to lunch in terms of the actual sentiments, the actual convictions, the actual beliefs of the American people. And I think the most important thing about this last election, even more important than Trump winning and defeating Hillary, in other words, even if Hillary Clinton had won, the fact that for the first time in a national forum with tens of millions of people watching, the moderator for Fox News asked about whether or not she supported abortion right up to birth. And she said yes. Trump said, but you know, that days before birth, how can that be? He emphasized it a couple of times. Finally, that's got through to the American people, to a lot of them, I'm sure. So that is just a tremendous breakthrough, but that hadn't happened for 40 odd years, and that's why people nominally support Roe versus Wade, even though when you ask the details about the nature of the decision, they overwhelmingly reject it. On the academic level, among teachers and scholars, the overwhelming majority, or maybe more than a majority, maybe everyone, almost everyone, rejects Roe versus Wade in the sense of saying it's not constitutionally well-grounded. That began right after Roe versus Wade and has continued today. The very respected professor of law, constitutional law, Michael Stokes Paulson, wrote, for example, in 2003, I do not know any scholar, judge, or lawyer who seriously thinks that the analysis who would seriously defend the analysis of Roe on a textual or historical foundation. It's truly extraordinary that the experts on both sides, pro-abortion and anti-abortion, from the conservatives and liberals, right and left, are in agreement about the absence of legal foundation in the reasoning of Roe versus Wade. Now, of course, the ones who are pro-abortion, they like the result of Roe versus Wade. They like it. It's more than they needed. It's more than they asked for. But yeah, hey, you know, your guys on top. You want to keep your guy on top. So it's not that they reject the result, but they don't try to claim the reasoning is good. One very important voice among that group of people on the left who actually are pro-abortion but reject Roe versus Wade was that of Catherine McKinnon, law professor Catherine McKinnon, who wrote an essay entitled Privacy Against Equality. And she pointed out what she's basically, her argument is Roe versus Wade in its thoughtless mercy, I'm tying this into our theme, in its thoughtless mercy was unjust, not to the unborn child, she doesn't care about the unborn child, was unjust to the woman. Ignored the harm that abortion was going to cause women. And here's what she says is the greatest harm, not a physical harm, but a harm in terms of sexual dynamics. In her words, abortion facilitates women's heterosexual availability. In other words, under conditions of gender inequality, and they sound weird or just politically correct, but she means sexual oppression, where men push women around. Abortion does not free women. It frees male sexual aggression. Referring specifically to Roe v. Wade, she says, the right to privacy looks like an injury got up as a gift. In her words, virtually every ounce of control that women won in Roe versus Wade has gone directly into the hands of men. Let me paraphrase her reasoning. She's arguing that those who in fact make the real life decisions are the ones who in fact have the real life rights, not the ones who nominally have those rights according to the law. So if women have a right to something or other, but men decide always whether they get it, and it's the men who have that right. I mean, same with kids. Kids have a right to go to parochial school, you know, I mean, it's not really the kids' right, it's the parents' right, right? Because the parents make the decisions for the kid. So, I mean, that's not just an abortion thing, it's in general. So that's what she said. So the result is that the right to abortion expands, but at the same time hides the oppression of women by fathers who tell their daughters to abort, husbands who tell their wives to abort, lovers who tell their lovers to abort, employers who make it difficult to work when pregnant or a mother and force them into abortion, and pimps. Pimps really innovate by Roe versus Wade. Those men make many abortion decisions and gain from it. If the woman aborts, the male in question is liberated from any responsibility for her, and at the same time, he keeps her as an object of exploitation, whether sexual exploitation in the case of a lover or a pimp, or employment exploitation in the case of an employer who does not provide adequate familial allowances and health care. In other words, McKenna is arguing that the thoughtless mercy of Roe has actually done in grave injustice, not to the unborn, but to women. Most surprisingly, and this is something I don't think McKenna touches on, her essay doesn't clearly touch upon this, even if the pregnant woman rejects abortion and gives birth to her child, she still loses under Roe v. Wade. How is that? Well, since the decision is legally considered to be hers alone, and especially if in fact the guy who got her pregnant offered to pay for the abortion, then he's going to feel like, well, the birth of that child is something she alone brought about by refusing to get the abortion. He's also going to think that the care for that child, the education of that child, don't come to me crying for help. You could have gotten an abortion. You made the decision to raise this kid, not me. I wanted the abortion. Her choice, her problem. That's the result of Roe versus Wade. And the result of this is not an academic argument or philosophical argument. It's quite clear to economists and many important essays, many important investigations, that the Roe versus Wade has resulted in a tremendously increased number of single families with just a single woman as the parent trying to raise kids on her own because of this abandonment of Roe v. Wade, by making it entirely her choice, encourages men not to feel responsible for the pregnancies they caused and to leave the woman alone. And interestingly enough, the current director of the Federal Reserve, Janet Yellen, was the co-author of the most important economic study in this regard, showing this effect on pregnant women, resulting in additional single mother families, single parent families. It shouldn't surprise us in this light that across the decades there has been consistently a higher percentage of women against abortion than of men. And I say that there's one little caveat. The only place where that's not true is at the very highest income and educational levels. I mean, Brian mentioned that Yale Law School, I saw a survey many decades ago, they were all, do you approve of Roe versus Wade? I think the men were 83%, and the women were 88% or something. So at that level, okay, because those women really, there's a tremendous opportunity cost for them to have a child, really interferes with this hard-driven, maximize your time of life, and they made that life choice. And so for them, even these downsides of Roe versus Wade, they still support it. But when you ask the masses of women, the average women are much more pro-life than men. Another big rejection of Roe versus Wade has been by state and federal legislatures. They have rejected the doctrine of Roe versus Wade, which can be put in this way: the location of the child in or out of the birth canal determines whether or not that child is a human being. That's how absurd Roe versus Wade is. The same, the child, a twin situation where one child is born at 9 months and one child, I don't know if this is physically possible, is born a week later, or it's even just an hour later. Second child is born an hour later. The first child is a legal human being, the second child is still not a legal human being, even though they're twins, just because one is still inside the womb. That's Roe versus Wade. Now, in an increasing majority of the states of the United States, it's now 34 out of 50, the death of an unborn child is legally considered a type of killing. And you can't kill something that is only potentially alive. That being has to be actually alive in order to be, to use the word cidio, feticidio, homicidio, to use the word side in English, to say that it's being killed. But even more telling, before Roe, and this I got from Clark Forsyth's wonderful book, no state recognized prenatal homicide as a crime during the entirety of pregnancy, throughout gestation. It began at some point after conception. But today, 28 of the 50 states protect the unborn child throughout all stages of development from conception. In Minnesota, for example, a person who intentionally kills an embryo just recently conceived in the course of an attack on its mother can be condemned to life in prison for murder of an unborn child. And in 2004, there was added to the U.S. Code the Unborn Victims of Violence law, very similar to those state laws. In an attack against a mother, this federal statute grants to the unborn child at every moment of his or her development the same protection that the federal law gives to the mother. In this and in many other legal fields, the unborn child is respected as a person who is actually there and alive, not just as something potential, as Roe v. Wade said. Now, the deep reason for this contradiction, some have called it schizophrenia in our law. And this is the one thing that people in Europe or Spain, Germany, South America, with whom I've lectured, this is the thing they can't understand, because they have this civil law tradition which says that the law has to fit together in a coherent theoretical scheme. So how can you say on one hand the unborn child doesn't really exist, just a potential? On the other hand, the unborn child is an actual human person, and killing that person puts you in prison for life. That doesn't make sense to me. Well, we're more accommodating in general in our common law system of contradictions, and especially with legal realism. But I think one of the reason for this contradiction is that we don't just lock step to the Supreme Court. We have consciences, and we have wanted children. I think that's the most important reason why the abortion decision has not gone away, because still, this could change someday if we turn more anti-life. At this point, most unborn children are wanted children, and the parents want to protect them. Since they want to be protected. They want to have legal protection. If somebody tries to kill my child, they're murdering my child. That should be illegal. So You know, that's the vast majority of people, so that's, the law's gonna adopt that point of view. The parents even they wanna take pictures of their babies. It's very hard to dehumanize a fellow human being who is so close and so beloved. You know, it's easier to dehumanize the Japanese or somebody who's far away, you know, during the Second World War, we dehumanized the Japanese. Because, you know, they weren't our immediate neighbor. We made sure they weren't our immediate neighbor, put them on concentration camp. Anyway, but it's very hard to dehumanize somebody if it's somebody close to you whom you love. And the vast majority of unborn children are still close and are known and more and more known through ultrasound and so on, and love. And so that's why we can never, I always tell pro-life people, you know, the last election is a big game, but no matter how bad things go, the battle may take a long time. It may go on throughout our whole lifetimes, but we can never lose because we've always got those sonograms, those ultrasounds. We've always got the proof there that everybody can understand that's a fellow human being, that's a beloved little baby. So that's something, we have something going for us. The U.S. Supreme Court itself has rejected many opportunities to reaffirm Roe versus Wade. Has never done so, to my knowledge. Richard may correct me, but I don't think that it has ever reaffirmed the reasoning of Roe versus Wade, though it's reaffirmed its hold. In 1992, for example, in Planned Parenthood versus Casey, the court for the first time in its plurality indicated a willingness to recognize the fetus as a child. Its word, child, present and alive throughout all of pregnancy. Quote, even in the earliest stages of pregnancy, the state may encourage the woman to know that there are philosophic and social arguments, by the way, not religious, philosophic and social arguments. Neither the German court nor the American court has ever claimed, like the media does, that the people who are opposed to abortion are just acting out of religious sentiments. There are philosophical and social arguments of great weight in favor of continuing the pregnancy. And the state may ensure that a woman's choice contemplates the consequences of an abortion for the fetus. The state may also express profound respect for the life of the unborn. The life, and this is the court's word, the life of the child the woman is carrying. Why then, if the court is willing to entertain the idea that this is an actual child, an actual living human being, why is it not abandoned its conclusion that there's a right to abortion on demand throughout pregnancy? The plurality in Casey responds to this that the doctrine of binding precedent, stare decisis, forbids the revocation of a Supreme Court decision simply because it has been erroneously decided. Making a mistake is not enough reason to correct your mistake. And furthermore, the court says, to admit a great mistake, to admit great mistakes is especially dangerous for the court. Quote, there is a limit to the amount of error that can be imputed to prior courts. Quote, if that limit is exceeded, quote, the legitimacy of the court would fail, end quote. In the words of the plurality, quote, a decision to overrule Roe's essential holding would address error, if error there was, at the cost of both profound and unnecessary damage to the court's legitimacy. In other words, to admit that the approval of free abortion on demand throughout pregnancy, was a great error, would result in an unacceptable loss of prestige for the court. That's why they wouldn't overturn Roe versus Wade. Shame. But most surprising of all has been the revelation in the last 2 years, after many decades, after Roe, that the author of the decision in Roe himself, Justice Harry Blackmun, was truly, and I say truly because it's not, it can't be, these are private correspondence, between him. He's not putting on a show for anybody. He truly thought that he did not leave the abortion decision open to the free decision of anyone. He thought, as apparently many or most of the justices thought in the majority, that the decision in the Roe v. Wade decision simply freed the woman's own regular physician to follow his professional judgment concerning whether the abortion was necessary to protect her health. The Chief Justice of the Court, Warren Burger, announced the same day as the decision, "It is clear that the court today rejects any claim that the Constitution requires abortion on demand." The text itself of Roe v. Wade, if you read it carefully, shows that the authors were not telling women they had a right to abortion on demand. The text declares that it is not the woman who is to decide whether or not to have an abortion, but the physician. Here are the words of the quote: "Without interference by the state, any decision," now not at first trimester abortion, because there can be a few medical limits, not to protect the child, but medical limits later on. "Any decision about first trimester abortion, quote, must be left to the medical judgment of the pregnant woman's attending physician," end quote. Because this decision, quote, "in all its aspects, is inherently and primarily a medical decision." It really looks like these guys, these justices, didn't think through what they were decreeing when they delegated absolute power to the abortionist. They gave the abortionist absolute power over the abortion decision, thinking that he would do it. He didn't really think it would help her health. But of course we know that there were a great quantity of doctors who couldn't make a good living elsewhere in some decent context, who dedicated themselves to doing abortion on an assembly line way with women they had just met 5 minutes before or during the abortion, you know, and very rapidly. So they just, I mean, if they thought 2 minutes, Justice Byron White in his dissent implies that that's going to be the result. You know, if the majority of the court had just thought about it for a moment, they would have realized it. How did they miss that? Well, the problem is that they never took seriously the issue before them. The Roe versus Wade and the companion case, Doe v. Oldham, were originally not about whether or not abortion, whether there's a constitutional right to abortion. It's rather, they were about what procedurally is required in order for that issue to be decided in a court. Should the federal courts abstain from intervening in until the state courts have prosecuted a doctor, or if they've already started prosecuting a doctor, should they wait till that prosecution is over? It was an issue of federal versus state jurisdiction. It was about abortion, but the issue was jurisdictional. The factual, there was no trial court debate about the nature of the unborn child. There was no cross-examination. There was no debate, no input of evidence about the risks of abortion to the mother. The only things that were in the trial court record were an affidavit, a complaint, an affidavit, and there was a transcript of the trial court debate, which was about procedural issues. But the court took those cases without any trial court record and decided we're going to decide the substantive issue. And they decided on the basis of their own research, judicial notice. I mean, that's really bizarre to decide completely controversial and debatable issues through judicial notice. And from amicus briefs, and sometimes from debate before the court. There were some substantive debates before the court. But without the test, you know, one of the glories of the law is an attempt to have a good factual record. They ignored that fundamental requirement. And the Roe versus the plaintiff in Roe versus Wade, the only woman plaintiff in Roe versus Wade, she was called Jane Roe in the case. Her real name was Norma McCorvey. Went back a number of decades later. She later repented of her role in bringing about abortion on demand. And she went to the court. She said, "Look, I want to reopen my case, or I want to start a new case on the same issue to fill in that factual gap. I want to have a trial where we can talk about does abortion harm women? Because look at all this evidence I've got that abortion really harms women. The court has never heard that. And Judge Edith Jones down in Texas, who saw the case, she had to turn Jane Roe down, or Norma Corley down, because, in her words, because of the doctrine of res judicata, but also of stare decisis, she said, and this is very telling, the court, once the court has decided it cannot look back, there's no mechanism to make it look back, or to permit us to look back at the lack of factual foundation. In this way of understanding the binding power of Roe, the court can never look back at its own factual suppositions with data proven in court. This, she said, is a structural judicial problem that leaves us in a state of intentional blindness concerning the dangers of legal abortion, according to her. And indeed, I would have to say this really is a structural problem. And I talk to my common law students, my jurisprudence students often about how to find a way to not be so rigid in our doctrine of stare decisis. But Justice Thomas seems to be the only one who's really working hard to overcome that rigidity, and we've got to push him well. Well, let me now quickly just sum up. I'm leaving with you guys the moral of the story. I'm not going to say what the moral is. The moral, there are two possible morals. One moral would be what's going to happen with abortion. Is just going to rear its head, its beautiful head, or is we're going to stick with just mercy? Does the arc of history come back in favor of justice, like President Obama said? And then the second question is about mercy itself. Does this case show us that mercy without justice can be dangerous? That mercy, looking only at the immediate circumstances, a sense of compassion, avoiding principle and reason, looking at but feeling immediate, doing what seems right now, is that a dangerous thing? Is mercy a bad thing if it's all alone? Does it need to be always accompanied by justice? Let me stop.
Our first respondent, Professor Dr. Versteegen.
Oh, yes. Yes, I'm here, Richard. Thank you. Thank you, Professor Stitt, for this passionate and well-informed and very moving and informative discourse. I'm going to try to be brief because I know some students might need to get to class. And I've been a respondent to a number of these. I hope you're not tired of me by now. Looking at la mia faccia brutta all this time, your trofeo. But I'm going to try to make a few points based mostly upon the written text. And I'm having to try to get a written text, but I noticed the title is awkward. But case in point, what is this philosophical question, legal question of viability and potentiality? And I know Professor Stitt is a background both in theology and philosophy, and I would just like to say how I'm very, frustrated by the loose use of language here, because when we say viable, you have to raise the question, if it's living organism of a human species, if it's living in the womb, it's viable in that particular environment. If we were to be brought out of our environment into an environment where there's not enough oxygen, we would not be viable. So the developing child is alive and viable, and that's why the whole idea of potential life, to me, is incoherent. You could have potential life with the egg and the sperm before the conception takes place. But once you have conception and it has all the signs of life, metabolism, growth, and so on, it's not in potentiality, it's in actu, as in Latin. It's actual life. So these are some points about philosophy and the linguistic and philosophical language used need to be taken into account. The other question I'd like to raise briefly is, whether or not we're dealing here with just pure, sound, legal and philosophical language, or whether we're dealing here with just simply people wanting something and finding then a legal maneuver to justify it. And I think Professor Stitt alluded to that in some comments he made, both in the written text and today. And you know, I was thinking of Germany here, and I was very happy to read, you know, those wonderfully moving words recognizing the dignity of human life at its conception, and that is human life, you know, according to 1975 Permanent Tribunal, and this was reaffirmed. But now, as I understand it, in Germany, abortion is legal up to the first trimester if the mother undergoes counseling and follows a 3-day waiting period. So this is a kind of lesson. You can see that it is a life, it's inviolable. Once you make exceptions, as is done in German law, then once you open the door and you say, well, it's a human life, but we could allow it to be killed under these circumstances, then those circumstances could be added. Well, what really happened, and perhaps could be talked about, Professor Stitt, I'm sure, knows more about this than I do, that after the reunion between East and West Germany, East Germany had legalized abortion, West Germany had not, so a compromise was reached, and that's where there was the present day situation. And you know, the Holy See had to be involved, because the question was whether these Catholic counseling centers could be allowed to sign the document allowing women to have an abortion, testifying that they had received counseling, and some thought, well, we should have Catholic counselors so that they could be persuaded against having abortion. But eventually, St. John Paul II decided, no, this was improper cooperation with potential evil. Now, last thing I would just mention about this, I think I've made my point about the flawed reasoning, and Professor Stitt did it so well. But I'd like to get back to some of the consequences of this. If you say it's a potential child until it's born, then, as he points out, it's written in his oral comments, it opens the door to infanticide. So in other words, if a child is not really human until it's born, but then there would be reasons to allow it to be killed. Think of people like Peter Sink from Princeton arguing that in favor of infanticide, and Mrs. Stitt brings this out in his written text. The other thing was there were cases in Illinois of this nurse, Jill Static, hypnotist, where there would be late-term abortions and the child would come out alive. And so she proposed, and some others proposed, a law saying born alive protection. That if a child is born alive after a botched abortion, so to speak, the child then is human and has a right to life and the care a child deserves. And this actually passed in 2002. There was only one state senator who opposed this provision, and his name was Barack Obama. Sorry to say, but that's on the record. But the last comment I want to make is I want to hear from Professor Myers, who's always so clear and concise, just like Professor Stitt, is we think that it argues the basis of logic and science. We should make these points. But there's also the potentiality of the corruption of human reason. And when people want something, they find a way to have it. It's like a will to power that some people have alluded to. But I'll just end with a personal story. I guess I'm dating myself. I was a college sophomore, second year at Dartmouth College, when there was the decision of Roe versus Wade. And in the student newspaper, there was an editorial praising this and saying, this is to simply prevent one group from imposing its morality on the rest. Well, you know that argument. So I wrote a response, and basically I said, well, were those who were against slavery, were they imposing their morality against those who favored slavery? It's a very basic point. So when I went to my English class, after the issue appeared with my editorial, I was verbally accosted by the professor. And she said, you believe whatever you want, but don't you go imposing their morality on me. This was in front of the class. Well, I was just shy of my 20th birthday. I was shocked. I said, I'll speak to you, class. So we had a long, detailed discussion. And the professor, I'm trying to argue, well, there's no, that's a line. Where do you draw the line? And at one point, I remember this like it was yesterday, she looked me in the eye and she said, I don't care for human life. I'm not going to let any effing Catholic church tell me what to do with my body. Well, I was kind of shocked. You know, you're young and you're in college and a professor uses vulgarity. But that happened. So I really should have complained, being attacked by religious viciously, but there were no witnesses to this. But then to the people in the grave, and I calmed down, and I told a friend the story, and he said, you should be happy that God gave you the situation where you could be persecuted for the sake of the truth. So, you know, in terms of mercy, justice, I would like to just stress, you have to have mercy on the people who fall into the pro-abortion mentality, mercy upon women who had abortions, because this wounds us all. We're much better than this as human beings, or with God's grace. So there's the justice for the child, but then we have to show mercy for those who fail. So I'll just end with that. Thank you very much.
Professor Myers.
Yeah, I really appreciate the remarks of Richard Stith and Bob Fastigi, and I know we're running short on time, so I'm just going to take about a few seconds to talk a little bit about this issue. I really appreciate Richard Stith making time, as he always has done, and since we've been here in Florida, to speak to us at this time of year, and I really appreciate his great insight. What I might do is, I know I'm getting royalties for this, is refer you to an article that I wrote on, it's entitled Rereading Roe Against Wade, that was published a couple of years ago in the Washington Evening Large in 2014, that talks about some of these issues and some of the critiques of Roe against Wade, some of which we've heard talked about this afternoon. One of the things that I mentioned at the beginning, picking up on a commentary that was in the New York Times, is that nobody really reads Roe against Wade, or at least not very often, and I think that's something that's worth doing for all of us, because if you reread it, what you'll discover is not only is it a horrible, unjust result, but the opinion is just laughable. Michael Paulson, which was mentioned earlier, says that Roe against Wade is a running joke in constitutional law circles. And I think that's true. The people defend the result, but they don't really defend the reasoning. And I think that if you go through in great detail and examine some of the defects, that should give us some hope that the foundations for the right to abortion in the United States are so deeply flawed that I think that makes it, the right there, insecure. And I think it's, the other thing that I think is interesting about this is that Roe is still in play, that this is over 40 years after the decision, but it hasn't been settled either on the Supreme Court, in scholarly circles, in state legislatures, and other areas that the decision is really deeply contested and challenged, and that ought to give us hope. I mentioned in this article that if you look at other areas of the law, that doesn't happen. Areas like the sex discrimination law that was changed very dramatically in the U.S. Supreme Court at just precisely the time of Roe against Wade in the mid-70s, is now settled, even though some of the same criticisms of those decisions were also made against Roe. Nobody holds conferences or gives talks on reassessing Craig against Warren, which is this famous Supreme Court case that deals with sex discrimination, because it's pretty well settled and entrenched, and there's some people that still contest it, but it's basically pretty well settled. But Roe against Wade, that's not true. As people are frequently pointing out the errors in it, pointing out how the harmful effects that it's had on all different areas. And so I think that ought to give us some hope that there still is this deep division and critique of Roe that suggests that it's still in play and it may get overturned when an opportunity presents itself. So I'll stop there, and I know that students usually ask questions. I don't know if we're going to, is that what
That would be fine if...
you're free of the article? I wish I got royalties, if anybody reads it, but.
I know I've used that article in my classes before, Professor Meyer, so thank you. From our panelists, the three sponsoring student organizations, Thomas More, Lexington, and Nancy Columbus, any questions, comments to our presenter or respondents? From the audience, yes, Professor Bonner.
Any tea leaf prediction on whether if one or two justices of the Supreme Court were replaced and whether Roe would finally be put to rest?
Well, I think it's, even without two justices, certainly if we had two, if Trump keeps his promises, we have good hope. But I think once the substance of Roe v. Wade is actually being debated, there's nobody who wants to defend that sort of law. I mean, 13%, 7% of the American people, it's just, you know, that's not the way it's going to be. And I just was reading the New York Times this morning that they said, you know, well, gosh, you know, if Roe v. Wade were gone, what if a woman couldn't get an abortion? Well, you know, she didn't know what would she do? And Trump said, well, she'd go to another state. You know, I mean, I mean, that's all they're talking about. So, I mean, Roe versus Wade is not, if Roe versus Wade is undone, it doesn't make the country pro-life. It just turns the issue back to the states. It unfederalizes the issue. And some states are going to end up pro-abortion, not like Roe versus Wade, but they're going to have abortion on demand in the first trimester, for sure. Some are, and some are going to be much more strongly pro-life. And the vast majority of abortions occur in the first trimester. And there's always a possibility of saving the life of the mother in virtually any state. So, you know, I mean, people are going to see it's not such a big deal, you know. It's not some radical, I mean, they think, you know, if Roe versus Wade is gone, all the women who have abortion are going to be in jail. Holy cow. A third of the American population, whatever it is, you know what I mean? A third of women, but anyway, no, that's not good. So I think once we begin talking about the substance, you know, the end is near, the light is there at the end of the tunnel. I would like to say something. I'm sorry, does somebody else have their hand up? Not that there are many hands left.
Do you have a paper also out, or?
Yeah, but it's in Spanish.
Oh, okay.
Sorry, I just don't have this in me.
Is there a reference to it? 'Cause Microsoft translates fairly well.
No, I don't trust people. But I mean, yeah, it's, you know, actually, the pair of minds are going to publish it at some point, and it also may be published. There's an inferior version of it that left off that Catherine McKinnon left with Harm to Women on the part, which is published in Peru in the Revista de Derechos Humanos from Piura, P-I-U-R-A, Universidad de Piura in Peru. So, and that would be it's a little different name. Instead of the original, the name in Peru was Grandes Rechazos de Roe v. Wade, Great Rejections of Roe v. Wade. And the current version, just to change the title to distinguish it, because the substance was a little bit improved, is fundamental rejections, rechazos fundamentales de Roe v. Wade. But that would be available. But Ligia has it over there. Ligia Castaldi or Richard Myers or Brian, they all have copies in Spanish. You're welcome to have the draft.
Richard, you may want to direct them to your press page. If you Google Richard Stiff, the press, you'll get all of his articles online and
That's
be able
right.
to pick them up.
Yes. Most of my articles do exist both. I mean, more exist in English than in Spanish. And those, I think all the ones that exist in Spanish, except for the one thing I've said today, also exist in English. So,
Is that by us, David?
it's S like Sam, T like Tom, I, T like Tom, H. Stiff.
Okay.
Richard Stiff, yeah. That's what it's- I did want to just respond a couple ways to Dr. Fastighi's remarks. I just quickly tell a little story I had when Roe versus Wade came down. I'm sorry, no, I read this one. That is, I was in law school, my second year, I think, of law school, or last year of law school. And my evidence professor had been on the court when Roe v. Wade was decided. She was clerking for Justice Marshall. And I had become sort of friends with her because I had a lot of questions about evidence, and I would go to her office and talk about evidence and all that. Anyway, when Roe v. Wade came down and people said, you know, you just don't know when life begins, I thought, I learned that in third grade. What do you mean? How do you not know life begins in conception? I said, huh? What are you talking about? You know, so, but my classmates would say, I don't know when life begins. And so I went and talked to her and I said, are you unsure about when life begins? She said, no, Richard, I'm sure it begins in conception. Oh, thank goodness. And did you try to convince Justice Marshall? No, I was in favor of Roe versus Wade. I said, but that pretends like life, there is no life, that's right. Well, why would you want to pretend like that? So I can have a backup for sex. I like to have sex. She said, she told me, I like to have a fail-safe. Concept doesn't work and I get pregnant. I want to be able to have an abortion. But you admit it's killing you? Yes, she said. The reason, and that's the fundamental reason among the elite, is not because the desperate situation that most people know they're never going to be in. No, it's because they want to have absolute insurance. They want to have all the sex they want, no matter what their marital state is. And if they get in trouble, they want to have a way out. That's it. The second thing is, I want to clarify Germany. Germany recognizes the existence of the unborn child, I said, throughout pregnancy. I was very careful to say it that way because the modern meaning of pregnancy starts with implantation. That's not my meaning of pregnancy, but when the firm connection is made to the mother's body, from that point on, the unborn child is protected as a constitutional right in Germany. The court doesn't say that there is a right to abortion or right to kill the child during the time prior to implantation. What it says is that case is not before us. The law that was being attacked in Germany, both in 1975 and in 1993, was a law that permitted abortion after implantation. Laws that permitted killing the embryo before implantation were not before the court. But the court's reasoning applies to that stage too. The court says as soon as there is life developing itself, there's a right to life. And that, of course, begins in conception. But the court didn't nullify any permission to experiment or so with embryos because that wasn't before them. Now, the teachings of that court, though, had a tremendous impact. And in fact, Germany outlawed IVF experimentation. You could have IVF, in vitro fertilization, but every embryo had to be implanted. There was none of this killing of embryos or freezing, freeze drying, or whatever, instant embryo later on or something like that, whatever they do it. Anyway, in other countries, but in Germany, every child from conception, by law, not by constitutional decision, had to be protected. I think a couple of years ago, that was changed. They can't change the constitutional decision, but I think they changed the law and permits the killing of some embryos, even in Germany. The immediate impact of the German decision was legislative protection from conception, even though the constitutional protection began only with implantation. Legality, the German court tried to do something. I mean, they really tried to be creative. They recognized the existence and justice for the child. They also recognized that with all the, they didn't use these words, but with all the promiscuity going on, there's a big demand for abortion. And, how are we going to bring these two things together? And their idea was, let's not use the criminal law in early pregnancy because, and this was a very interesting reason, the mother in the first 3 months doesn't really show. And so nobody is going to know whether she has an abortion except her and the abortionist. Whereas after 3 months, the mother shows, and therefore prosecution can more easily take place, and social pressure and all that kind of thing. So during the first 3 months, but what we want to do, we want to be able to reach pregnant women with pro-life counseling and help. We want to tell them that the government guarantees them a partner for themselves and the child. We want to tell them that they're guaranteed paternity support, that they're guaranteed employment, all by the Constitution. We can't reach them and tell them that they're going to sneak underground to some abortions. So what we're going to do in the first 3 months, we're going to say, okay, you can have your abortion, but only if you go for pro-life counseling first. It has to be pro-life. The mother has to be told in Germany, your unborn child has a constitutional right to life. You're taking the life of a person with a constitutional right to life. That's what she has to be told. But after she's heard that, and she waits 3 days, she can then have an abortion. And the idea is that they would save more lives by taking abortion out of the underground in those first 3 months where it's going to be because of the hiddenness of the pregnancy, and trying by positive means and counseling and support to stop the abortion. You know, my wife is German. Rosemarie is here with me today. You know, I know a lot of people in Germany. My impression was that it just didn't work, you know, that once you say that you can have the abortion in the end for any reason, as long as you go through formalities and wait for 3 days, you know, that people are just not going to be sufficiently profoundly thoughtful and reflective to appreciate that kind of guidance. It's kind of like the issue of, a little bit related to the issue of divorce and marriage. Our church is talking about now. I mean, the idea is that the norm is marriage is sacred. You can't get married unless you're married once. But we're going to let people work that out in their internal conscience. And is that going to work? Or are they going to ignore the norms? You know. Well, I think our Pope is hopeful that they won't ignore the norms. And the Supreme Court in Germany, Constitutional Court in Germany, was very hopeful that people would not ignore the pregnant women going through this counseling, would not ignore what was being said, and would decide not to take the life of their child. But my impression from people in Germany was that it was having no effect. It was just a formality. One of the things I discovered in Chile, I was interviewed by the leading legal newspaper in Chile, and I must not have been very coherent in what I said because they never published the interview. But one of the great things that the interviewer told me, he said, "Can you explain to me why the abortion rate in Germany is so much less than the abortion rate in France?" I didn't even know that. The abortion rate in Germany is much less than the abortion rate in France. But if that's the case, then the German approach is having some good impact. You know, if you just say it's a woman's right, like in France, maybe it doesn't help. But if you say, no, the baby is there, the baby has a constitutional right, you know, well, they also, I mean, they have rules for the media, too. The media cannot, just like you can't use the N-word for a black person, you can't call the unborn baby a blob of protoplasm or something like that. No, that you can't use negative terms for your fellow human beings. You have to have sensitivity and all that kind of stuff. So anyway, maybe the German approach is having some good effect. You know, maybe not enough because of the anecdotal information I've come across, but maybe it is having some good effect, despite the fact that there's no penal punishment for abortion after counseling and waiting 3 days in the first trimester.
Well, we're already over time, but if our panelists would like to say just a final concluding remark, and it seems we're not being pushed out of the room, we'll give you a last comment, and we'll call it an afternoon. Everyone get some lunch.
Thank you.
Thanks. Professor Myers is declining. What about Professor Fastidi?
Well, thank you. I think we've covered the subject, but in terms of mercy, you know, just to think in terms of the need to change hearts and not just minds. Because even if we outlaw abortion tomorrow, people would find a way to have it. We have to change hearts and not just the laws.
That's true. It reminds me of what I believe John Paul II once said, that ultimately life issues and the culture of death leads us to new evangelization. And that without returning to Christ, so many of these problems are almost intractable and unsolvable. Thank you all for your time and your great contributions to our conversations here. Thank you.
Thank you.